On item B8 with City Attorney Kyle Finnell and Assistant City Attorney Michael Rea are here to present information-only discussion regarding proposed updates to BMC Chapter 9.32 entitled Unauthorized Camping.
Thank you. So I'm going to direct your attention in your packet to the publication prepared by MRSC and the Association of Washington Cities entitled The Homelessness and Housing Toolkit for Cities. It's the 2022 version. This is a periodic publication, and this is the most recent one available. For me, I downloaded the packet from the website, and it's at page 33 for me. And I did not include this as a mistake. I included it in its entirety because I think it's a really good visual reminder of what we're here to talk about and what we're not here to talk about tonight. And so you'll notice from the table of contents, it starts at page 135. Okay. And I'll give you guys all a chance to get there. This is a large document. There's approximately 60 pages, and it's divided into, there's an introduction, there's a section on funding, there's a section on homelessness, there's a section on affordable housing, tenant protections, and innovative collaboration, and then, of course, their acknowledgements and stuff. But the reason I wanted to include this is because if you'll notice, homelessness and the limits of enforcement under homelessness starts at page 8 of the publication, is just one little line in all of these different topics. And a reason I'm pointing that out is that to sort of focus the conversation on the council's task of amending this ordinance, and as a kind of also a visual reminder that there's a lot of other work being done that you've undertaken, that you've supported with regard to these other issues, and that this discussion of the ordinance is just one piece of the entire process for affordable housing and addressing homelessness in our community. I certainly encourage you to all take a look at the publication in its entirety if you haven't read it before. But for the purpose of tonight's discussion, and as we go through this process of updating the code, we're really only going to be focused on the pages that are talking about homelessness and the limits of enforcement, and that starts at page 8. So if you could kind of go to that section, I'm going to talk about why we're here tonight. And I feel like this is a pretty good explanation of what's going on. You'll see when you get to the page 8 of this publication, it talks about various topics. And the first one that you see right there in bold is Martin versus City of Boise. That's a Ninth Circuit case. We're in the Ninth Circuit, state of Washington is, that the Ninth Circuit declared it unconstitutional for the City of Boise to enforce its ordinance prohibiting camping in public places against people experiencing homelessness at times when there was no shelter space available. And so that was a case that a lot of cities on the West Coast, including all the cities in Washington, were certainly taking note of, because that ordinance that Boise had was very similar to ordinances that are in place all across the country. And so that's what the court ruled was unconstitutional. However, the court did set some limits on the scope of its decision. And if you notice right there in the middle of that page, it goes into a list. It goes 1, 2, 3, and that's really what I want to talk about. And there's 4 things. It doesn't cover individuals who have access to adequate temporary shelter but choose not to use it. So the focus of the decision is on involuntary houselessness, homelessness. It is not, the scope does not extend to people who simply are making that choice to not access temporary shelter. Additionally, when shelter is unavailable, an ordinance may prohibit certain things at certain times or in certain locations. And we're going to get into that later when Michael talks about what other cities have done in response to this. Additionally, an ordinance can prohibit obstructions of the right-of-way or erecting certain types of structures as a part of an ordinance. And that an ordinance is consistent with the 8th Amendment, whether it is, will depend on whether it punishes a person for lacking the means to live out the universal and unavoidable consequences of being human. And that's the quote from the Ninth Circuit. The city of Boise did petition the Supreme Court for review. That was declined, and so the Ninth Circuit law stands. There was another case that is not mentioned in this that came out more recently. It was at the end of 2022 that reinforced a lot of the holdings in Martin v. City of Boise. And it's my understanding that they have petitioned the city in that case, which is Grants Pass, has petitioned for additional review by the Ninth Circuit, and the decision has not been made on that yet. So more to come, but in the interim, really what we're here to talk about are these 4 points. And that's kind of going to be the focus of this exercise of at what point are we going to limit the use of the public areas, public right-of-way, parks, that kind of stuff, public property, public space, and how it interacts with those who are experiencing homelessness. I did want to just, if you go on to the next page, and this is at 145, there's also discussions on searches on vehicles. I'm not going to be touching on that too much, but I did want to draw your attention to panhandling regulations, which is it's my page 146. You might recall that last year we did deal with this already. We repealed our section that we thought was not in line with the holding in Willis. And so the council has already been undertaking this work. And this is just an extension of that work continuing to go forward to make sure that our codes are in line with case law. And so to help you with that decision, what we have planned for tonight is that Michael's going to talk about what other cities have done in response to these decisions and how they've revised their codes. We've got examples from City of Longview, the City of Lakewood, as well as City of Portland, which had a really publicized revision to their code in recent weeks. And then those are certainly not the only ones who have done updates. It's been pretty common for cities to be looking at this. Our plan is to talk to you about those, answer questions. The item is currently set for the 5th for public comment only. We are coming at you with a proposed ordinance. We really are hoping to draft this with you guys with input from the public. And then we would come back to a study session on the 12th, talk again about what we all learned from the public comment piece. At that point, Michael and I will start getting the ideas together of what this council, this community wants to see in an ordinance. And then my goal would be that we hopefully have at least something then to consider for presentation on the 19th, but certainly opening up to other ideas and timelines if the public comment deems that that's what's required for this. So that's kind of the introduction. Before I kick it over to Michael to talk about the specific examples, does anyone have questions, or do you want me to?
Sure, I'll take questions, comments.
Yeah, one of the things we talked about, I guess, and that's a good comment, why this isn't going through committee, is it really touches on so many different departments and whatnot that we thought council as a whole was the best place.
My question was, so I know that the Supreme Court denied cert from Boise's appeal. Are there any circuit splits? Are we anticipating that the Supreme Court might take this issue up?
I don't think that the other circuits have had a case go up where they've reviewed it, and I'm not 100% sure. I know that if you read the dissent in the most recent Ninth Circuit case, I would encourage you to read it. It is definitely that it basically says that it should be heard en banc, and that if not, then appealed. And so I don't think that there's any circuit splits right now that I'm aware of. I know that other states are going completely opposite, completely different directions.
Right.
And
I would imagine the 5th and the 10th
right,
quite different.
Yeah, I had heard that Tennessee had proposed making it a felony to camp in public space.
Yeah. Thank you for that. I guess my next question is, for these elements that the Ninth Circuit kind of carved out as exceptions, other than the second case that you mentioned, has there been any ordinances testing the ability to
right
work within the frames without violating the 8th Amendment?
So there have been I guess, no, not directly on the nose, I guess is what I would say. The approaches are definitely locally crafted. And so what I haven't seen is like a model ordinance come out, which sometimes there are, like, for example, when the Supreme Court decided the Reed v. Town of Gilbert and required basically every sign code in the country to be amended, there was, it was a local process, but at the same time, there was kind of the model ordinance. I haven't seen that. This has definitely been each community sort of looking at their situation and what works best for them and crafting an ordinance to go along with that. And you'll see from even looking like Lakewood and Longwood View, which aren't even that far apart, right? It's pretty different.
That's it for now.
All right, Denise and Jennifer.
Sure.
You said there were 4 items you want us to talk about. Or you want
Oh,
us to
sure.
frame? Okay.
Sure. So in this MRSC AWC publication, it's on
Which page? Oh,
it's
sorry.
144 of our packet, but it's page 8 of the publication itself.
144, page 8. Got it.
Is everyone, I downloaded mine from the internet. I think sometimes it, yeah. But and so on that initial page, it has the title at the top, homelessness and the limits of enforcement. There's like 3 columns of text. You see what I'm saying?
Yeah.
Like, so in the middle column, if you go down kind of in this way, it says, however, in footnote 8, the court set forth some limits on the scope of its decision. And these 4 elements are where cities are adopting codes that are in harmony with the decision and not running afoul of the holding in Martin.
And just one thing before we continue, from my end, I looking at the current Bremerton ordinance, so I just want to make sure I got it correctly, that the current ordinance as it exists in Bremerton is basically no camping anywhere, anytime, for any reason. And so no matter what action we take, it would be a more lax policy.
Right now, our code prohibits camping anywhere all the time. That's not okay. And what the Ninth Circuit is saying is that you can't have a blanket prohibition anywhere all the time. You have to specify, but you can, however, specify certain areas as being no camping anytime, or you could do a time restriction, because the Ninth Circuit focused on the act of sleeping, not just, and Michael will talk about that. Portland kind of took that approach recently. And so that was why I was talking about that. When you'll see that, particularly point number 2, even when shelter is unavailable, an ordinance may prohibit sitting, lying, or sleeping outside at certain times or in certain locations. And so that mix of times and locations is where certain cities have revamped their codes so that it is not as broadly prohibited and instead is narrowly tailored to the uses in their community that they've identified.
Okay, thanks for clarifying that. All right,
I think what you're asking about is would the court take into consideration a person's competency in determining whether or not their exercise of not going to shelter? And I don't think in the analysis that the court was looking at in the choosing not to, didn't specifically look at that element. It was more about whether or not the person had a place that they could go. And if they did, then the city was then at that point, I guess, able to enforce their ordinance against that person, because the 8th Amendment, so it was not implicated when the person had a choice in the matter. It was the lack of shelter space and having no choice but to go to sleep where they stood or where they, because there was no other place for them to go. A separate issue though would be if I guess free from the 8th Amendment restraint, the city then prosecuted that person, their lack of competency could then be an issue in the criminal prosecution that would result in a dismissal. And so that is certainly a possibility, but it's also, I guess for like what it's, I don't think that the issue of competency, it certainly wasn't what the Ninth Circuit was looking at in this context.
Okay, thank you.
I could add to that, Kelly, and Council President Coughlin, you previously raised what our current ordinance says. So on its face, that the ordinance is potentially problematic. And so that, I think that's a big part of the reason to at least make some amendments to it, so that it is in line with this newish case law.
You have a couple.
Can I,
Look for thumbs up from council to let Mr. Rea continue with his presentation before we do more discussion. All right. See.
Jennifer, does she still have her hand?
Yeah, well, we've done one round, so I'm looking for consensus to move on to
I can hold
presentation
mine.
before we have more
I'd like to hear,
discussion. But
I'd like to hear Vice President
I think
Chamberlain's
we
comment.
need Michael and Eric to either thumb
Yeah.
up or thumb down because it's a majority body.
Eric, Michael, thumbs up or thumbs down to hear Michael's presentation before more
Hear
discussion.
the presentation, please.
Okay. That's all right. So I got majority. Yeah, let's get the presentation.
All right,
We'll
thank
do
you.
Discussion.
So yeah, we thought it would be useful to look at what some other jurisdictions in the Ninth Circuit have done in response to this as well. The first one, and all the ordinances are in your packet. The first one is the City of Lakewood, and that takes the approach of putting up a tent, making a shelter area, camping, etc. Is always prohibited in certain areas, and that is what they have called protected waters. That's defined in their preamble of the ordinance. They also include a map that shows exactly where those areas are. So at all times, with no exception, camping of any kind is banned there. And then further on in their code, there is the sections touch on it. Well, essentially, it bans camping throughout other public property within the city. However, there's a pretty big exception to that. And what the exception says is that enforcement will be suspended if there's no available overnight shelter that can be used by that particular person. So they also include a definition of available overnight shelter. That's pretty common in jurisdictions that use that method, where they suspend enforcement when there's no shelter available. They will almost always include a definition of what shelter space or available shelter space will be. As far as penalties go in that ordinance, there's no warning here, but the penalties do increase as the offenses increase in number. So for example, the first offense is there's no mandatory minimum penalty, but as it goes on to a second, third, and subsequent offense, it looks like there's a little bit of mandatory jail time as well as mandatory fines. So then another approach, the second ordinance, Longview, City of Longview.
I just want to take a pause right there just to temperature check everyone. So when we went back to that, what I was talking about, the Ninth Circuit said that there can be basically time and place restrictions. Lakewood is an example of a place restriction. So Lakewood took the approach that their protected waters, which are places that were for critical habitat, wetland type areas, that they were experiencing pollution related to illegal camping and was harming those areas. So they took the approach that those were going to be off limits all the time without regard for whether there was shelter space available or not. Then every other place in the city was only enforceable, or every other place that's in their code is only enforceable if there was shelter space available for that person. And that's where it gets to that element of it being in the choice or not to the choice of the person. And so this is, I was included just as an example of a city who did a location-based restriction and did And they've chose critical habitats and things like that as the place that they were going to protect all the time from illegal camping with regard to shelter space. So I'm just kind of summarizing it, going and tying it back to what I started with and looking at those things. And so, okay, next one.
Yeah, so Longview would be the time restriction. So what they have done is between the hours of 6:30 a.m. and 9:30 p.m. No camping is allowed, and they list a variety of locations. It's pretty extensive. It includes any park, any publicly owned or maintained land, parking lot, or other publicly owned or maintained area, and also any city street. So I think you'd probably be hard pressed to find any area in the city of Longview that allows camping inside of those 6:30 to 9:30 hours. On top of that, they prohibit storage of property in that same area during those same times. So the practical effect would be that, you know, somebody can camp at 9:30. They can start to camp in those areas. By 6:30 a.m., then they would have to move all of their things out of there and move them to a different location. So that would be the practical effect. The Portland ordinance, obviously not a Washington City, but it's still in the Ninth Circuit. And so that kind of takes a combination of all of those restrictions. What they do is they also have hours that camping is not allowed. That is between 8 a.m. and 8 p.m. But on top of that, they have a variety of areas that camping is never allowed in. The use restrictions they have, so and there's potentially would be a lot to go through there, but that page and a half, you know, press release from the city does give a pretty good synopsis of the changes that they've made, and they restrict things that are, I think that they've deemed that are related to safety, so open flame, human waste, things like that. They have a section on penalties that, so they're what they're doing is taking a kind of a phased in approach. Evidently this is actually very recent, within the last several weeks. So as far as getting the word out on how this is going to work, they're doing community outreach, and then before any penalties will go into effect, there has to be proof of 2 written warnings of a violation of the ordinance. It's not really specified how that would be tracked, so there's potential difficulty there. But like I said, I mean that's a good example of an ordinance that kind of takes a little bit from each type of what's out there and applies it to our city. So those are good examples of you know, different approaches that the jurisdictions have taken in response to this. And unless Kylie has anything further to add, you know,
Right.
that's her additional questions.
Yeah, and my understanding is that the Portland ordinance, that if a person doesn't have an alternative access to shelter or housing because it's not available, then that person may camp, but they have to follow the time, place, and manner regulations implemented by the city. It's the enforcement is only when there is an alternative available, but even within that, the person is required to follow those time, place, and manner restrictions. And so that's fairly recent. And my understanding is it's been passed. I think my understanding is that they took like 5 hours of public testimony before they amended their code. It is supposed to, I think, start next month or this month.
They
Next month.
are, I think, starting outreach
Now, I think it's
now,
outreach.
and the earliest enforcement will be in effect is the end of July.
And so, again, it's coming to you because of the Ninth Circuit decision, and that our current ordinance is anywhere all the time, never okay. So the least, I guess, and these are the ways that other cities are handling it. Another alternative would be to simply repeal it like we did the panhandling ordinance. And then it wouldn't be in our code at all.
So, yeah, we'll go to comments and questions. But yeah, I did want to reiterate it. It wasn't our goals and procedures we all voted on to update this specific ordinance this year. And then the current proposal on the floor is to go to a public, that's not a public hearing, but
No,
to take
just
public
accept
comment
public
next
comment,
week on
yeah.
this. You would represent this to the public. We'd hear public feedback, and then we'd reconvene a study session to discuss
Sure,
more options.
right. And if we needed another, I mean, it's on our goals. Obviously, I think it's on everyone's goal either this year or last year to do this. So, and when I say everyone, like most cities are addressing this, we're not unique in that. If you look at, Portland just redid theirs, Lakewood's was 2 months ago. Everyone's sort of doing the same thing. And so, but it is definitely, this is a change that's coming out with a lot of local variation.
All right, so let's go to council